Hey everybody, John Skiba here from the Arizona Consumer Law Group. I'm also the founder of the Consumer Warrior Project, which you can learn more about by going to legal.coach. There I have a lot of free resources, downloads, templates. I also have some online courses for people who are dealing with serious debt problems and ways that people can try to resolve that themselves without having to get an attorney involved. In today's video, I want to talk about kind of an age-old question that I get in my practice quite a bit, as far as whether a person should file for bankruptcy or whether they should try to settle their debts directly with their creditors. Now, there's a couple things that influence, in my mind, as far as which route you take on that. And that's what so I wanted to discuss those specifically. You know, I was meeting with a person in my office today, and they were going through this battle. They said, you know, they have this number of creditors they're trying to deal with. The accounts are delinquent. They're getting the phone calls. They're dealing with the stress. It's impacting other family members. And so they're trying to decide, you know, hey, I want to get rid of these, but I don't want to file for bankruptcy, which I fully understand because bankruptcy is a big decision. It has its own set of consequences, stays on your credit for 10 years. You will recover from it, but definitely it has its own set of problems that can come along with filing for bankruptcy. So what I wanted to share with you is something that I told her, and I tell, frankly, all clients who are going through this decision-making process, as far as how you decide whether settlement is going to be a good option. Now, I'm assuming a couple things for this conversation, and that is that we are talking that you're dealing mostly with unsecured debt problems, things like credit cards, medical bills, maybe some personal loans. Those types of debts can be settled, and they can generally be settled for quite a bit less than's actually owed on them, particularly if they're delinquent. If you haven't made payments on them in months or maybe even years, maybe it's a junk debt buyer like Portfolio Recovery or Midland Funding that's now coming after you instead of the original creditor. Those types of accounts can be settled for quite a bit less, sometimes as low as 10%, sometimes high as half, 50% of what's owed. But generally, you can get some kind of deal in place to so that you don't have to pay the full amount and you can avoid bankruptcy. However, the first thing that I ask people when they're trying to decide between debt settlement and bankruptcy is let's look at how many accounts you have that you need to settle, because issues arise if you have a large number of accounts. If someone comes to me and they want to do a debt settlement and they have 15 different credit cards and medical bills and things like that, I always say that's when it's going to get a little bit tough, because in order for debt settlement to really be effective, we've got to get all these people on board. It doesn't help you that much if you go out and you settle half of these and then the other half are still, pounding on your door and filing lawsuits and doing wage garnishments and things like that. So if there's a large number of creditors, that's one of the factors I look at where I start leaning towards maybe a bankruptcy is the way to take care of that, rather than if you have just like a handful, 2 or 3 or 4, or maybe even 5 credit cards that you need to deal with. That's a little more manageable. The odds are much better that we're going to be able to settle those accounts, and you're going to be able to deal with them globally and not have to worry about some straggler that's going to cause you problems down the road. The other thing that we look at, and maybe this should have been the first thing we talk about, is do you actually have the ability, financial ability, to settle these accounts? And what I'm talking about there is, frankly, do you have the money, the lump sum that's necessary in order to make the settlement work? My preference and the creditor's preference is generally that you do have some kind of lump sum that you can go to them and pay pretty quickly. Generally, you're going to get better deals if you have a lump sum. I usually ballpark most accounts, and you got to have at least half, and then we'll work to try to reduce things to get a better deal than half. But if you don't have half the amount owed to be able to come in and pay, say within 30 days of making a deal, it's going to be a little more difficult. You can set up payment plans, and some creditors are willing to do that. I can tell you my experience is generally that the days of a creditor just taking $25 a month on a large account are over. I don't really see that. There are exceptions to that rule, but in general, I don't see that. So when it comes to payment plans, what you got to be really careful of is that if they agree to it, and first of all, if they agree to it, they're probably going to require something near the full amount, if not the full amount. But you've really got to be aware of interest, because if interest is continuing to accrue on the account, you may be in a situation like I remember a guy I met with a couple years ago where he entered into this payment plan with one of these junk debt buyers. He's making the payments each month, and then 2 years into it, they sent him a statement that was showing that he actually owed more than when he started, because the interest was at such a high rate that the amount he was paying each month was not even covering that interest payment. So generally, I recommend that clients don't enter into a settlement agreement where they're going to be making monthly payments unless the creditor agrees to 0% interest. No more fees, no more interest. You'll pay off the amount that you're settling for, but you don't want to deal with any of this interest or fees that they're going to try to add on top of that. So those are really the main things that I look at when trying to decide between bankruptcy and debt settlement. Is really you've got to first look to see if debt settlement's even a possibility. It may not be a possibility based upon the number of creditors you have and your ability to settle. Large number of creditors is more likely going to be bankruptcy, and then frankly, if you don't have the money to settle, that's going to make the decision a lot easier as far as how you deal with that. So if you want to learn more about debt settlement, I actually put together an online course that can kind of walk you through some of the strategies that we use when we help clients with debt settlement. You can learn more about that at legal.coach. It's the website we have there on the screen. There's also a bunch of other free downloads and other resources that we have for clients and non-clients who are looking for just some help and trying to figure out how to solve the debt problem. So you can also, that's all part of our main website over at consumerwarrior.com. If you're listening to this and you're in the state of Arizona and you'd like someone to go over your specifics of your case, we're always happy to meet with people. We do free consults and can give you some more information there. That'll do it for this video, and we'll catch you next time. Thanks.